So we need to talk about a recent 9-0 unanimous decision issued by the Supreme Court involving the Fourth Amendment's protections and when excessive force by law enforcement impacts those rights. The Fifth Circuit has now issued a new ruling potentially defying that decision by the Supreme Court, and this could already be heading back to the Supreme Court really soon. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, I want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form is an amazing company. They're pro-freedom, pro-America, and they support the Second Amendment. And also they have great supplements. So if maybe you're trying to get healthier or you have a New Year's resolution, check them out using the link down below. And if you buy any supplements using that link and you buy supplements, you'll get a free 5-pack of protein sticks. And I also highly recommend their protein powder. It's one of my favorite products that they make. Now, as I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous decision issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures and when law enforcement activities through excessive force impact those rights. The unanimous decision came in a case called Barnes versus Felix, and this case may already be heading back to the Supreme Court for re-review just 6 or 7 months after the court issued that ruling. That is because the Fifth Circuit has issued a new ruling in this case in light of what the Supreme Court said in that 9-0 decision. The Fifth Circuit has once again ruled that the officer's actions are protected even under the totality of the circumstances approach. And the en banc panel in this case in the Fifth Circuit decided to deny review to this issue. The Fifth Circuit has engaged in some very interesting reviews of this case after the Supreme Court decision and remanding this case back down to them. And really this tees this case up to go back to the Supreme Court once again for re-review in light of what just happened, in the Fifth Circuit. Now, the facts surrounding this case are as follows. Essentially, an officer, Roberto Felix Jr., pulled over an individual, Ashton Barnes, for suspected toll violations. I believe that there were some cameras in the Houston area that picked up, the license plate of this vehicle. There were some claimed toll violations. There was potentially also that this was a rental car with toll violations. And because of that, the individual was pulled over by the officer. Now, what ended up happening is the officer told Ashton Barnes to exit the vehicle, and Barnes opened the door and acted as if he was going to exit the car, but then he attempted to drive away, which was a bad decision. Now, reacting in a split second, the officer decided to jump onto the ledge of the car as it was driving away, which again was another bad decision by the officer, but he jumped onto the ledge of that fleeing vehicle. Now, grasping onto the car as it was pulling away, the officer then decided to pull his firearm and then shot Ashton Barnes twice, and then Ashton Barnes was fatally shot and passed away at the scene. Now, because of this incident, Ashton Barnes' mother sued the officer on behalf of her son, alleging that the officer violated Barnes' Fourth Amendment right against excessive force. Now, on review, the district court granted a summary judgment in favor of the police officer, applying the Fifth Circuit's moment of threat rule. The Court of Appeals affirmed, explaining that the moment of threat rule requires asking only whether an officer was in danger at the moment of the threat that resulted in his use of deadly force. So essentially, under the rule, events leading up to the shooting are not relevant and cannot be considered. This case made its way all the way up to the United States Supreme Court, and on review, a unanimous Supreme Court in a 9-0 decision held that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. That inquiry into the reasonableness of the police officer requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis that was applied by the Fifth Circuit in this case, and instead they applied the totality of the circumstances approach. The Supreme Court stated that most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. So the main thrust of that ruling by the Supreme Court was rejecting the more limited scope of analysis applied by the moment of threat rule. Instead, the Supreme Court orders lower courts to look at the totality of the circumstances before, during, and potentially, immediately after the incident as well. Anything that really plays into what happened during that incident. Now, after the Supreme Court issued that ruling, the case was then sent back down to the Fifth Circuit for re-review to apply the correct totality of the circumstances approach. Instead, the panel in the Fifth Circuit decided to not hold oral arguments or ask for additional supplemental briefs or briefs in light of what the Supreme Court just ruled in this case. Instead, they just re-ruled on the case on their own without additional briefs or oral arguments. Now, in the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were still warranted. The panel reasoned that any vehicle flight creates a deadly threat and that Felix reasonably used lethal force to prevent a dangerous chase. Now, because of that really quick decision without additional arguments or briefs, Barnes' attorney then petitioned for Fifth Circuit en banc panel review in that case. The petition argued that this new ruling by the panel contradicts what the Supreme Court just said, and even also contradicts what Judge Higginbottom had already said earlier in this case in his concurrence, where he said that the deadly force would be unconstitutional under the totality of the circumstances approach if they were forced to apply it. But now on re-review, even under that analysis where he said there was no way that the officer could win, somehow they still ruled that the officer could win. That petition urged for a rehearing en banc because the new ruling effectively created a per se rule that officers may shoot any fleeing driver even when a minor stop is potentially involved. They argued that this conflicts with the Supreme Court cases with long-standing Fifth Circuit precedent that fleeing in a vehicle does not automatically justify deadly force. However, the Fifth Circuit en banc panel has already denied review to this case, so really quick after that petition was filed for a rehearing en banc, it was denied really quick by the Fifth Circuit, and the order there just simply said that the petition for panel rehearing is denied. And so essentially they said no member of the panel was interested in reviewing this case or looking at what the three-judge panel said in this case in light of what the Supreme Court ruled already in this issue. As a result, the Fifth Circuit three-judge panel just issued their official mandate on the 21st of December, closing the case out officially in the Fifth Circuit. And Barnes' family now has until February to decide if they once again want to take this case back to the Supreme Court. So this is something that we'll be watching very closely to see how this plays out. It's surprising that the Fifth Circuit panel decided to issue a new decision on this case without essentially requesting additional briefs or oral arguments in light of that new ruling by the Supreme Court impacting this very case. And now even the en banc panel has denied re-review of this case despite what the lower court said in their decision. This now teased this case to go back to Supreme Court already just 6 or 7 months after they ruled on this very issue. Remanding it back down, telling the Fifth Circuit here to re-review this in light of what they said. But again, like I mentioned, the Fifth Circuit decided to just issue a new ruling without additional briefs or oral arguments. The plaintiff here argues that the Fifth Circuit has failed to properly apply the new Supreme Court ruling, and they may go to the Supreme Court once again and ask for the Supreme Court to finally step in. So that is what is happening right now in this critical case, which was recently ruled on by the Supreme Court and may already be heading back to them for re-review just, a few months after they just issued their ruling. So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Also, you can check out one of the 2 videos here on the screen that the YouTube algorithm thinks that you will find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.